Oh, it's that time of the week, one of my favorite times of the week. It's the midweek edition of Legal AF with Michael Popok and Karen Friedman, Agnifilo. We got at least 4 hard-hitting, news-breaking stories at the intersection of law and politics we got to talk about today. We're going to kick it off with the Trump trial, part 2, and its aftermath. The gag order, what happens to it? Donald Trump wants to have it removed before the June 27th debate with President Joe Biden. Prosecutors don't, and have set up and asked for a briefing schedule related to the continuation of the gag orders in order to prevent the undermining of the administration of justice in New York while he is released and before Donald Trump is ultimately sentenced, and how those two things sort of fit together. Who better to talk about it with and kick it around with than my colleague, friend, and former prosecutor in that office, number 2 in the Manhattan DA's office, Karen Friedman, Agnifilo. We'll talk about sentencing and the sentencing options, what goes into the sentencing process in a state court proceeding in New York, and what would happen if Donald Trump were to appeal, which we know he will, and how would that impact sentencing? We'll talk about all of that. And talking about cases that did not get tried and look like they're not going to get tried before the November election, we got to move down to Georgia. In March, Judge McAfee ruled in a long-winded opinion after several days of an evidentiary hearing that Fani Willis, the prosecutor in the case, did not have to be disqualified under certain conditions. Donald Trump didn't like that, took an appeal that was certified by the trial judge, and it's moved up to the intermediary appellate court in Georgia, the Georgia Court of Appeals, just under the Georgia Supreme Court. Unfortunately, the hearing on whether Fani Willis should or should not have been disqualified, or the oral argument, if you will, has been set for June as a control date. I'm sorry, has been set, that was wrong. Let's try that again. Has been set for October as a control date, which sounds good at first blush, like, all right, well, they'll take it up in October, except that will impact ultimately the trial setting for the case and whether or if that case ever gets set for trial before the November election. We'll walk through the appellate arguments, what's happened, and what it means for the case. And speaking of cases that are have been delayed, this time by judicial foot dragging, we've got Judge Cannon down at Mar-a-Lago with the espionage and national defense information purloining case of Donald Trump. And we got our, as Ronald Reagan would say, we've got our here we go again moment. Cannon has decided that she finds the argument whether the special counsel has been properly appointed and funded to be really interesting, despite the fact that that argument's been rejected expressly by multiple appellate and federal district courts around the country, and has been implicitly rejected by the United States Supreme Court. But not to Judge Cannon. She finds it so interesting. She's going to hold a hearing at the end of June, and why not invite a bunch of other quote-unquote scholars, most of which are Trumpers, to argue why the special counsel has been improperly appointed and the whole thing should just disappear. Doesn't that sound fun? And while she's doing that, she's postponed other hearings related to Donald Trump's request to interrogate and depose members of the Department of Justice and the FBI about the investigation. You know what every criminal defendant, run-of-the-mill criminal defendant, would love to do and is regularly granted in criminal court. Every criminal defendant gets to sit the Department of Justice leadership down and the FBI and talk to them and interrogate them about his or her individual criminal case. The answer to that is no, they don't. And but then another thing that Judge Cannon finds interesting, so interesting, she hasn't even set that hearing yet. And you know what that means for the setting of the trial, which has been indefinitely postponed by Judge Cannon. We'll break it all down. We'll talk about what's going on there. And we'll contrast it to some other trials going on around the country that happen to involve Democrats. And then finally, Wisconsin has finally woken up. The Attorney General there taking the lead of the Arizona Attorney General, Chris Mays, who broke the glass ceiling about a month and a half ago, as we reported here on the Midas Touch Network, and brought the first criminal prosecution against fake electors and those that help fake electors, like many people surrounding Donald Trump in a conspiracy. The Wisconsin prosecutors have decided, hey, that probably happened here too. We should maybe do that also. Although they did not indict any fake electors, they have indicted again, Ken Chesbro, Jim Trupis, and Mike Roman. Those names are familiar, probably because you remember that, or should know that Ken Chesbro, one of the architects of the fake elector scheme, along with Jim Trupis, was not only indicted in Georgia, which we'll talk about today, but already pled guilty to a felony and is allegedly cooperating with certain people, but not cooperating enough for some people. Jim Trupis has been indicted already once before, and Mike Roman also indicted in Georgia and was a unindicted co-conspirator in some other cases as well. And we'll talk about what that means, and for the other battleground states that continue to investigate, even though we are X amount of time beyond Jan 6, the investigations and prosecutions at state, attorney general, and Department of Justice levels continues. You know what else continues? Legal AF, a little podcast we invented 4 years ago, just for this particular historic moment, apparently. And I couldn't ask for a better midweek host or host period than Karen Friedman Agnifilo, who is, because life always intrudes on all of us, is away, but has decided in her generosity to join us at the regularly scheduled time. Karen, delight to have you back.
Yeah, I seem to be on the road a lot, so It's good to be here.
It's always some, for all of us, it's always some pale green, indiscriminate room with an electrical outlet and some.
Yes,
right.
Yes,
People might be thinking, how successful are these lawyers? Look at the rooms they operate at. My favorite is when people see you on the set of Law and Order, where you are the legal advisor on the law side. And they think you're in some sort of caged. Look how bad New York is. She has to have, poor woman has to have cages on her window. I've actually saw that in one of the chats. I'm like,
it's because I like to be in the set of the police precinct. That's where I like to be more than the DA's office set or the courtroom set. So I don't know why I feel comfortable. I feel comfortable in the police precinct.
Because you're an order person. You're law and order, and you like the order part. Let's talk about what's going on. Speaking of order and orders of operation, let's dive right in to the Trump trial. We all know what happened. Now we're going to figure out what happens next. And again, I think, you and I batting this around now is great. Imagine anybody waking up and think, what happened? He actually got convicted? Yes. We're now talking about the aftermath.
Let me tell you, just going back for a minute to the conviction, there is no feeling more stressful than the moments between when you are told the jury has a verdict and the time that it takes to get the jury to come in, to get all parties assemble, to stand, and to literally, your heart is pounding so hard you can feel it in your throat, you can hear it in your ears. And I'm sure for the defendant, it's worse. And everyone's standing there to find out what your fate is. And it's one of the hardest moments and one of the most stressful, intense moments of being a prosecutor or a defense attorney or a defendant. And I had that feeling waiting for this verdict. I was sitting actually on a panel on CNN, and CNN had people in the courtroom, and they were they were live chat, or live streaming, I should say. People were typing, reporters were typing, and they were live streaming, and just the waiting, knowing that, okay, the jury's in the room, the judge is on the bench, the parties are standing, all of that. I had that same feeling again. And sometimes what happens is with a multi-count indictment, sometimes the first count or the first couple of counts are not guilty, and you're crestfallen only to find that the rest are guilty. And so I was thinking, okay, what if it's torture. The 34 counts, it takes a long time if the first one is not guilty. If the first one's guilty, you're like, okay, whatever happens next, happens next. And it's one of those times in your life where you'll always remember where you were. I remember in 1982 or 83 when the space shuttle exploded, I remember where I was, and it's like a moment frozen in your brain. I obviously will always remember 9/11, and And one of the other times in my life that I will never forget is that feeling of Donald Trump being found guilty. It just felt like a relief, and like the fact that truth sometimes still matters, and that our democracy matters. And sometimes it's not like a celebratory feeling. Some people ask, what does it feel like to get a conviction? Do you pop champagne? Do you go out and celebrate? At least for me, it was never like that, and still isn't. It's never a good feeling. Obviously, the fact that somebody is convicted felon and could go to prison is a terrible feeling, because it's sad, right? It means something bad, really bad happened. So you don't feel joy, but it's like a feeling of relief that it's hard to explain unless you've experienced it. Anyway, I don't want that moment to be forgotten, because it was so historic and so important, and so just heartening, actually, that the truth still matters in this world of misinformation that is coming from so many people, so many of the MAGA people.
So eloquently put. Yep. I mean, that's for all the naysayers that said he'll never see the inside of a courtroom, he'll never be indicted, the appeals will. Apparently, according to polling, 54% of at least Republicans, because they believe the pabula coming out of Donald Trump and his proxies, believe that he would never be convicted. They really thought that was not happening. And so there's a little bit of a shock going on in MAGA world. They're like, well, wait, what? And then, of course, he gives them the talking points. It's kangaroo court. It's rigged. It ain't rigged. It's not a kangaroo court. It's 12 honest, hardworking jurors picked at random, selected through an arduous selection process, doing their civic duty, who listening and weighing the evidence that's presented to them with 22 witnesses over 6 weeks, combined with documentary evidence and recorded evidence and everything else relatively quickly, given the fact, as you've described before, sort of the creaky process by which they have to have certain items brought back into them to consider, made a relatively high velocity decision, even though it was 9.5 hours. It really wasn't, of deliberation time. And as you and I had talked, and Ben and I had talked about, I always thought it was binary, that they were either going to fine for all 34, it was going to be 34-0, or it was going to be 0-34. And as soon as I heard the first one, I think Ben and I were on the air at the time when I was filling in with a bunch of other people on Political Beatdown that happened to be playing at the moment of the that was regularly scheduled. I was like, oh, this is going to go fast. This is 30. All right. And then within 5 minutes, we had all 34 counts in. Let's move it forward, though, because I think the audience is interested and concerned at the same time about things that could happen next. Let's start with the gag order. Then we're going to get to sentencing, because I think that's very, very important. As I know you do, about what this judge on July 11th is going to do in terms of sentencing. Let's start with the gag order, though. I'll frame it, then I'll turn it over to you. Conditions of release. And let's all remember that in every court that Donald Trump is a criminal defendant, or in this case, a felon, a convicted felon, he is released subject to the discretion of the trial judge, who administers the criminal justice process for that individual defendant. And his liberty is at the discretion of that trial judge, and the conditions of the release, whatever they are, in every state that we talk about during this podcast: Georgia, New York, DC, and Florida. Donald Trump has been released on his own recognizance, subject to conditions of his release, and they're a little bit different in every place, but there are some fundamental things that are the same. And in New York, as I said, as soon as he was out, unless the judge modifies them, he is still subject to all of the conditions of his release, including the gag order on the way out. And Trump, you could tell, was mindful of that, because although he thinks that if he says the shitty thing about the person, the family member, the prosecutor, or the judge, and just leaves out the name, that somehow doesn't violate the gag order. Like when he calls Michael Cohen a sleazebag, but doesn't use Michael Cohen's name, but identifies him in every other way. My former lawyer who took the stand, who's got a podcast, is a sleazebag. I don't think that technically it complies with the spirit of the gag order, but we'll leave that to your old office to figure that out with Judge Merchan. But the gag order is still in place, as it is with every defendant. Whatever the conditions of release are, they continue. Of course, Donald Trump doesn't like that because, A, he's got a debate coming up on the 27th of June, which he wants to be apparently completely reckless and freed of any constraints other than the laws of defamation, to go after Joe Biden. And they, Joe, the president finally, after 2 years, said something about my case. I get to say something disgusting back. No, you don't. And your old office, and I'll turn it over to you now, your old office, in response to the letter brief, which was filed by 2 out of the 3 lawyers for Donald Trump, Todd Blanche and Emil Bove, but not Susan Necklace, who's not even listed on a CC there, as we can see. We'll talk about Susan Necklace slowly receding into the vapors behind this case, about what that means. But your old office has already responded about that request. So why don't you take it over from there?
Yeah. So look, I mean, Trump, as you said, really wants to be able to say whatever he wants to say and criticize people. And the Manhattan DA's office said, not so fast. They said, look, we have to protect, the court still has a broader obligation to protect the integrity of these proceedings and this case and the judicial system. And it should remain in effect at least through sentencing and maybe through appeal or post-trial motions. And so they want to brief it. They want the same briefing schedule for post-trial motions that the judge already set. And so keep it in effect until sentencing. And look, many of us have been wondering why Todd Blanche didn't, at the time of conviction, ask that the gag order be lifted. Maybe he did, and we just didn't hear about it. This is not a surprise. And then they said, well, because they're also appealing it right at the Court of Appeals, because they had appealed it and it had gone to the appellate division, and then they rejected it during the trial. And then they're appealing it to the Court of Appeals, which is the highest court in New York. The Supreme Court is actually the trial level court. I know it's very strange. And so I think that's where they thought they had to go, was that route. But they could also just ask the judge now to lift it, which they finally, I think, woke up and decided to do. It's interesting, as you said, Susan Necklace is basically distancing herself. But, she was always, first of all, she's a real lawyer. She's a real defense attorney. Todd Blanche just became a defense attorney. I think this is his second client. Since he's been a defense attorney, he was a federal prosecutor for a long time. And Emil Bove similarly. So Susan Necklace, who's been around for a very long time, if you notice, she never stood next to Donald Trump during his mid-break press conferences. Todd Blanche always did. She's always in the background because she's just a defense attorney who believes in representing clients, and she doesn't get involved in any of the stuff that Trump likes to use his lawyers for, which is smart. She just does her job and does an excellent job. And she's very, very good in court. And I think she's starting to distance herself even more now that the trial's over. So at least I certainly don't know why she didn't put her name on it, but it's consistent with, I think, how she's been. She didn't do the opening or the closing, which are the 2 most important parts of a trial, people would argue. She also didn't do the cross of Michael Cohen. She did do the cross of Stormy Daniels, but that's typical. A lot of people think that women should do the direct and cross of other women, that men, it could look too harsh, all that kind of stuff. So, and so it's just now we're at the point where the judge is going to decide what to do. I think where the judge is going to land ultimately is, I think he's going to continue the gag order for the jurors indefinitely, because the jurors never should become free game for the defense, ever. They should not. I mean, all they have to do is cite to Shay Moss and Ruby Freeman to show what could possibly happen, what Donald Trump does to people who are literally just doing their civic duty. If you remember, they were the election workers. One of them was a volunteer election worker who in the whole I don't even know where to start. It's such a long story, but it's the Rudy Giuliani defamation election workers whose lives were turned upside down and who were doxxed and threatened and harassed and all of the above. There's so many examples of people who are just doing their civic duty. And I think that the judge is going to want to protect them and all future jurors who might be hesitant and reticent to sit on a jury if they know that that's what could happen to them. So I think that's going to stay. I think same with the family members of public servants, whether it's Juan Merchan's, the judge's family members, or the DA's office family members. I mean, they should never, ever be harassed or threatened. And I'd say the same with the public servants who are the line prosecutors. The witnesses, of course, there's an interest in protecting the witnesses, but I could see the judge modifying the gag order to the extent that, like Michael Cohen, for example, is already talking about Donald Trump again. I could see the judge thinking that he is somebody it would be fair game for them to lift the gag order for him. But Stormy Daniels has not spoken. And so I would be surprised if she doesn't continue to be protected, as are the other witnesses. Again, it's just about in protecting the integrity of the judicial process and witnesses in general. No one's going to come forward if they know they can get threatened and harassed, et cetera, after the fact. So that's where we are with the gag order. So it's a stay tuned thing.
Mm-hmm. No, I agree with you. And the judge has already sort of laid the foundation for lifting the gag order as it related to people like Michael Cohen. He implied that he's not going to allow his gag order to be used as a sword and a shield, where the witness, particularly in that case before the trial even happened, sort of hides behind the gag order, but then reaches out and attacks the defendant, and then says, "Well, I thought you had a gag order." So he's not going to allow that. And now that the case is over and moving towards sentencing, what I want to talk about when we come back from our first break is, okay, the judge modifies in some way after some sort of briefing schedule here that the prosecutors are proposing, which seems reasonable. He modifies the gag order, keeping certain elements of it in place about certain aspects of the criminal justice system, administration of justice, which all makes sense, considering that's still going on even through appeal. And he hasn't even been Trump hasn't even been sentenced yet. But then I want to talk about a little bit when we get into sentencing. Now that that's lifted, all of these, how Donald Trump's post-conviction conduct, even now sort of complying in his own weird upside-down way with the gag order, or no, as modified, or not complying with it, goes into the mix of the sentencing and sentencing options by the judge. In other words, it's not as if the judge just puts his hands over his eyes and his ears between the 34 count conviction and the day of sentencing and just sentences him as if nothing happened in between. We're going to talk about the in between, because I think with a guy like Donald Trump, that becomes very, very important. So modifying that gag order could just be enough rope to hang Donald Trump on the sentencing. But of course, I want to kick it around with you, Karen. Georgia. Yeah, we're going to talk about what's going on in Georgia, and including a new order that's popped out that is going to make it so that trial is not happening before November. And we'll go into the details of that. We'll talk about Judge Cannon and what in the here we go again moment, where she's decided to find lots of things interesting and invite lots of non-parties in to come in and talk about it over the months of June and July, making that case a virtual uncertainty of not happening. And then we'll talk about Wisconsin Attorney General getting around to indicting people around Trump. Is that the last group in Wisconsin? And what about the fake electors? What about Donald Trump? What about Rudy Giuliani and all the other people? Why Troopus? And why only Troopus, Roman, and Chesbrough? We'll talk about all of that. We got a great crop of pro-democracy sponsors curated by this channel, by this network, by Jordy Mycelis and the rest of us. And now we're going to take a break for a set of them right now.
I'm a parent and a grandparent. I want to live a healthy lifestyle in order to be around for my kids and my grandkids for a very, very long time. And living a more heart-healthy life will fuel everything you do. So this 3-in-1 blood pressure support that Super Beets Heart Chews has created is just a absolute game changer. So if you pair it with a healthy lifestyle, the grapeseed extract in Super Beets is clinically shown to be nearly 2 times more effective at promoting normal blood pressure than a healthy lifestyle alone. New Super Beets Heart Chews advanced support healthy COQ10 levels and are an important nutrient for heart health. I love Super Beet Heart Chews. First of all, they taste absolutely delicious. They help you be mindful about your heart health. And I just feel good knowing that I'm having something that's good for my body every day. I literally eat 1 or 2 or 3 of them every single day. I look forward to them. They are healthy. They are good for me. And like I said, it's like having a nice little sweet treat. So it's just this absolutely delicious, effective, and clinically researched product, Super Beets. It's the #1 doctor, pharmacist, and cardiologist recommended beet brand for cardiovascular heart support health, something important at my age for sure. So they also support healthy circulation, and there's no stimulants, which I love. So find out how you can get a free 30-day supply on bundles of new Super Beet Heart Chews Advanced and save 15% off for a limited time only by going to superbeetsradio.com, promo code LegalAF. That's superbeets radio.com. Promo code LegalAF. Don't tell anyone, but I'm actually a cat person. And I don't like cat food. It's disgusting. Either it smells bad or those little hard, terrible things that with hard food that cats don't like. My cats don't love that food. And I don't like it either. I don't like giving it to them. But our next partner has truly made a positive impact on my little kitty cat, who I love, who you've seen jump into some of our podcasts or into my hot takes or even my ad reads. And I'm talking about my kitty, Cooper, who's just a sweetheart. And so I am so, so happy that Smalls is absolutely one of our great new sponsors. It's a cat food that is protein packed, and these recipes are preservative free, these ingredients that you would find in your own fridge. And it's delivered right to your door. And that's why veterinarians, veterinarians.org, they rate Smalls 10 out of 10 for ingredient quality. And when I gave Cooper Smalls, he loved it. He ate it all up, unlike those little hard, crunchy nugget, disgusting things, or that smelly food. He absolutely loved it. He prefers it more than he preferred his old food. And I even put side by side his old food and Smalls because I wanted to see, is it true? I'm going to be doing this ad read. And guess what? Cooper chose the Smalls. Yay. So I love Smalls. It's definitely made it more pleasant for me to feed Cooper. And it also makes it so that the house doesn't stink like cat food. And I don't know, I just feel better knowing that I'm giving Cooper a really good quality with good ingredients cat food. So I love it. It's great. And I think he will love it too. I think you'll love this protein packed meal for your loved one too, if you love your cat as much as I love mine. So after making the switch to Smalls, 90% of cat owners reported overall health improvements in their cats. And I think that's a really big deal. This team at Smalls is so confident your cat will love their product that you can try it risk-free. That means they will refund you if your cat won't eat their food. Pretty great, right? So now's the time to switch to Smalls. Head to Smalls, SMALLS.com/legalAF and use promo code LegalAF at checkout for 50% off, 50% off your first order plus free shipping. That's the best offer you'll find out there, but you have to use code LegalAF for 50% off your first order. So that's promo code LegalAF at smalls.com. That's plural, SMALLS.com for 50% off when you insert code LegalAF plus free shipping.
And we're back.
It makes me,
thank
by
you
the way,
to
it makes me so happy to see a picture of my cat. I'm like, oh, Cooper, in the middle of an episode. Puts me in a good mood.
That's nice. That's good. We thank the pro-democracy sponsors for being here, including a new one there. Smalls. I want to talk about sentencing. I'm going to give you some options, former prosecutor, and then we'll talk about this gap of time and what it could mean for any of these options. Probation, and they're not exclusive. Home confinement, jail, community service, and fines. That is the toolbox. You'll probably tell me there's something else I missed, but that is the preliminary toolbox of what Judge Merchan can put together in his powers to sentence somebody who just got convicted of 34 counts, 34 Class E felonies in New York, with an outside upper boundary of 20 years total for all of those things. And then at the other extreme, which is some sort of probation or community service. And I want to ask you to comment on that, and particularly, whereas in the federal system, you've got the federal sentencing guidelines that sort of guide the court. State in New York, I want to hear what is the alternative to that. Is it the parties getting together and looking through the way Just Security did and looking at all of the cases over the last 30 years or 40 years in which somebody like Donald Trump or anybody was convicted of this particular Class C type felony, and then what was the range of sentences for that? Does that go into the mix? And how does the judge, with the information that he's provided between probation, parole or probation and the parties, and then makes his own research and decision, and then those elements: probation, home confinement, jail, community service, and fines? What do you think? What do you think is going to happen here?
So it's a great question. You left one option out, though, which is that he could get, well, no, but I mean, he really doesn't have to give him anything. He could just say, a conditional discharge, the condition being that you just stay out of trouble and don't get whatever.
So number 6 is conditional discharge. All right. So far end of the extreme is this conditional discharge. Other end of the extreme is top end 20 years total.
Yes.
Okay.
There's a big range in the in this possible sentence that Judge Merchan. Look, Judge Merchan has a very, very tough decision here. I will say he is one of the best judges I've ever been in front of. He's one of the most thoughtful judges I've ever been in front of. He volunteered and is the head of both the mental health court in Manhattan, as well as the Veterans Court. Those are courts where people come before him charged with pretty serious felony cases, violent crimes and other crimes. And those are people who come to him who are filled with remorse and want help and want to change. And he shows them mercy and he helps them, and he will sentence them to treatment or alternatives to help them get on toward a path of changing their life and transforming, as opposed to incarceration and punishment. And I bring that up because I just want people to know what kind of person he is and what he will do. He always does the right thing, and that's what I've seen. So whatever he decides, I'm sure is going to be the right decision for this case. He's lived it, he's breathed it, he knows what the legal issues are, and he will make the right decision. What do I think? What would I guess he's going to get? I don't think he's going to put him on probation because I think just it's very tricky to supervise someone on probation. Also, you don't put someone on probation unless you think they are going to comply with probation. And I think the idea of having a just absolutely, civil servant, type person who will have to supervise Donald Trump, who's guarded by the Secret Service and may be president, I think is just almost a ridiculous proposition. So I don't see that happening. I don't see Donald Trump listening to some person who he's not going to necessarily respect. So I just don't see probation happening. I also don't know how that would work if he's president, et cetera. That's on one extreme. On another extreme is jail time or prison time. The difference between jail and prison is jail is 364 days or less, and then that's called city time. Or if you get a year or more, it's called state time, and you serve it in a state facility versus Rikers Island, which is the New York City correctional facility. I don't see him getting jail or prison either, even though if his name was not Donald Trump and you just strip that away and you had a case of somebody who has been convicted of 34 felonies and the underlying bump up crime was that he had to steal an election, or at least conspire, I should say, to try to steal an election. I can't think of a more serious Class E felony. In addition to that, Donald Trump violated the gag order 10 times and was held in contempt. So in front of Judge Merchan, he's also shown and demonstrated just an FU approach to the criminal justice system and to authorities. So if his name wasn't Donald Trump, the judge would say, look, I don't think you are someone who puts your own interest above that of society's. You break the law, you bend the law, you don't listen to authority, you do whatever you want. I had held you in contempt 10 different times because you didn't stop. And you show no remorse because he's going out and he's denying it. He's not saying he's sorry. He's saying he's innocent. And he's also attacking the judge, attacking the judge's family, attacking the DA. He held a baseball bat to a picture of the baseball bat to a picture of Alvin Bragg's head. Any other defendant would have been put in a long time ago and would get at least the 4 years. I don't know that anyone would get 20 years. I think that's extreme. I think at most, maybe you'd even get 2 of the counts running consecutive to each other. So it would be 1 1/3 to 4 times 2 would be 3 to 8, I guess, years. So it'd be a minimum of 3, maximum of 8 years. I could see that being the sentence of any other defendant. But I don't know that Judge Merchan is going to want to be in the position where Donald Trump is incarcerated during the presidential election, or when he could possibly be president. That's just not. It gets a little too close to the First Amendment and Article 2 of the Constitution. So I don't think he's going to choose that either. A fine he will never choose because, as he said when he held him in contempt, for someone rich, a fine doesn't mean anything. It's not punishment. So I think, and what I would like is to see him get sentenced to a conditional discharge, the condition being that he is sentenced to 100 hours, 500 hours, 1,000 hours of community service, but not community service that he gets to choose, the kind of community service where you pick up trash on the subways. And that's punishment. And I think that's real. And I could see that being meaningful. And I could see Merchan doing that. So that's the type of sentence I think he might take, he might consider. I could also see if he does want to sentence him to jail or prison, that he would consider staying the sentence pending appeal. Again, just to allow, because there is a couple of non-frivolous appellate issues that I think will be upheld, but they're certainly non-frivolous. So I think any sentence will be stayed anyway. And I don't think he wants to touch those waters. So that's where I think he's going to land. But I've never been a judge. I don't know. But that's where I think he's going to land, some version of that.
So a couple of points to pick up with on there. Way back when on sentencing. I would the average sentence for this type of thing is somewhere between 4 months and 2 years from the analysis that's been done by others. I'd like to see a sentence in that range. The problem is they're going to have to, besides the First Amendment problems, besides the executive privilege problems, the Article 2 problems that you identified, you also have the problem of when you send Donald Trump to jail, you send the Secret Service to jail as well. And so while our jail and prison system in New York is robust and very little surprises them, having to make way for Donald Trump and a group of armed Secret Service people in jail, because that's going to have to happen by law. He has to have Secret Service protection, even he doesn't forfeit it just because he got convicted of felonies, especially nonviolent ones. So he's going to have to grapple with that. One of the ways he could deal with it is defer it, as you said, but maybe defer it not only for the appellate stay, which is inevitable, but also to get over. He doesn't have to sentence him on July 7th or 11th. He could say, I'm going to wait to sentence you at another time, maybe, and wait for the election to happen. I don't think he does that, but he could, or he could say, I'm going to give you 4 months, but I'm going to pick up with it. You don't have to report until November the 6th or something like that. And then have those outlets for him to go do the appeal and get the stay and all of that. I agree with you. I think it's a very difficult, although we'd love to have his head on a pike. And we'd love to, there's an element of vindication and vindictiveness and a little bit of vigilanteism that comes in with this, an eye for an eye. We like to say, he committed those crimes and he's a first-time offender. It's hard to believe he's a first-time offender, at least at the time of these crimes. And yes, I think that Merchan's going to have to incorporate and integrate his bad behavior, Trump's bad behavior, between now, the time of the conviction, all the way through the time of the sentencing. And I'm sure the prosecutors will point it out. And then you have those separate things that the judge hasn't yet resolved, which is the criminal contempt issues. Because in those criminal contempt issues remain important, not just because you can't let him get away with it, but because of the conditions of release in other jurisdictions are subject to him not committing any new crimes. And so there's going to be the argument there, although we're going to talk about Georgia and what's happening at that note. I agree with you on probation. I don't think he's going to discharge him. And then you're trying to find something that is an appropriate penalty and also sends the appropriate message to community and public at large, which is crime doesn't pay. And that is the needle, that is the camel through the eye of the needle that this judge has to come up with. I wouldn't be surprised if it went exactly the way that you described it. And I wouldn't be shocked if he figured out a way to give him some sort of jail or prison time. And by delaying or deferring elements and aspects of it, try to address some of the other unique issues that you raised, because Donald Trump apparently is going to be, regardless of what we all feel, the nominee for the other major party in this country to be the president of the United States. And that's a problem of their own making. We didn't choose their candidate. They chose their candidate. They want to choose a criminal for their candidate. This is what happens when you do that. I hear you trying to come in. Go ahead.
No. Thank you. No, just look.
Mm-hmm.
You make some really good points. And I thought of the same thing of he could push off the sentences, but it's not like he didn't know if he was convicted, there'd be a sentence. He would have done that at the time. They picked July 11th quick. So I kind of feel like that ship sailed. And then the other thing, if I'm Judge Merchan, Michael Cohen went to prison for how long? Years, right?
3 years. It was reduced because of COVID.
Yeah, I mean, he spent prison time because of this crime. Alan Weisselberg is in now for his second 5-month stint. And to have people go to prison, but not Donald Trump, not the guy who caused all of this, the reason we're here, there's a fundamental unfairness about it. So I am sure no matter what Judge Merchan does, he's going to, his sentencing remarks, because what happens at sentencing, so what's going to happen just really quickly is Donald Trump has to report to probation, where the probation officer will fill out a form that makes a recommendation about what probation thinks should happen. It happens in every case. It's called the pre-sentence report. Then the parties, if they want, can submit sentencing memos where they argue for one thing or another and give all the reasons why. And then the judge sentences him at a sentencing hearing where the defense gets it, the prosecution gets an opportunity to make a public statement about what they think the sentence should be. The defense is given an opportunity to make a statement of what they should think it should be. And then the defendant gets an opportunity to make a statement, and they can or cannot. They don't have to make a statement. Sometimes what they'll do is they'll plead for leniency and say they're sorry and apologize to the United States for doing this and all of that stuff, right? And hope that the judge will listen to that. And sometimes they do. Sentencing hearings can be tearjerkers. I mean, I've cried my eyes out at sentencing hearings because that's where the victims get a chance to come and make a statement and make a victim impact statement. And the final thing that happens is the judge makes the statement. And the judge's statement is usually profound and powerful, and it explains why they're doing what they're doing and what their sentence is, and really is incredible. And I am sure Judge Merchan's, this is going to be the sentencing speech of all sentencing speeches. And I'm sure one of the things he's going to talk about is the carnage that Donald Trump has left in his wake, including the people who have gone to prison because of him. And somehow he will also acknowledge the constraints he has if he had to incarcerate him, and if he does incarcerate him, and if he doesn't, he'll say, why not? Now, Norm Eisen, who works for Brookings and Just Security and who's been on this pod and is a friend, he, with Brookings, did an analysis of all the Class E felonies in the history of New York and what the sentences are. And he drilled down from that to the falsification of business records cases and what those sentences are. And only about between 10 and 30% of them get any jail time at all or prison time at all. But it's, and the fact pattern of those are very egregious, but this would be even more egregious. So certainly he'd be well within what's consistent with other cases and where prison is justified. So, we'll see what he does.
I mean, look, the reality is the very few cases go to criminal trial and verdict. It's amazing when the funnel system in this country, federal and state, from when indictments happen to when, there's always that old line about if you're a criminal defendant, don't go to trial with the prosecution because you're going to lose. Like 98% of defendants lose at trial. But the reality is that there's only about a very small percentage of those cases that even go to trial. So the chances of conviction is not high either. But once you cross the Rubicon and you're into the world of trial has set, and we're going to talk in a way we're going to talk about when we get to Judge Cannon about all the delays down there. Contrast that with Hunter Biden, 8 months from indictment to trial. That's the reality. So I've seen Norm Eisen's as I mentioned before, just security analysis, but that also has to be, for those that don't practice law, has to be put up against the prism of very few cases go to trial in these arenas. The fact that things went to trial and then, of course, went mainly against the defendant. And as you said, 20, somewhere around 20%, 10 to 30% end up with jail time. Certainly the theft of an election, which was what the jury has to have believed based on the opening statements and the evidence presented by the Manhattan DA's office, is right up there with one of the greatest heists of all time. You can't put a dollar value on our democracy, and that jury, how to find that. Let's switch gears now and go to the other case we keep talking about in contrast to everything, because she just finds a way to contrast herself with everything, is Judge Cannon. The Mar-a-Lago case started with a search warrant 2 years ago. And now we're still jerking around and around in June of 2024, not even talking about a trial date anywhere on the horizon. We're talking about, I think it's interesting whether the special counsel has been properly appointed or not, or funded properly. And there's a recent Supreme Court decision about the funding of the Consumer Protection Board. That seems very interesting, not related at all. And I want to hear a comment on that. And there's people here that have filed amicus briefs and they want to be heard, and mainly Trumpers. I think that's interesting. Why don't we all get together? Let me look at my calendar. Why don't we all get together on the 27th or the 23rd of June, and let's talk about these things. Fundamentally, whether the prosecution should have even happened because a special counsel was improperly appointed and improperly funded. That's interesting. To whom? First of all, let's start there. And then, if she ever picks her way through that gauntlet of her own creation, minefield of her own creation, if the case survives that, then it will be, and then appeals, of course, that would result from that. And that's what the Jack Smith's been waiting for. Then it's the gag order is also interesting. I don't think you filed it appropriately, the prosecution, the first time. I think you needed to redo that, and then delay. And they finally got around to filing it appropriately the way she liked it, with all the hospital corners and creases the way she exactly liked it. And she, we'll get around to that. How about also, we'll do that on the 23rd too. So that delays the eventual appeal. That's now another, 20 days away, whatever it is. And then also, I think it's interesting whether Donald Trump, this is the judge talking, I think it's interesting whether Donald Trump should be able to interrogate and depose in a criminal case the prosecution and the Department of Justice, and whether they should get more documents from these entities about the execution of the search warrant and his having stolen documents from the American people, including those consisting of national defense information documents. This case is quickly, in the mind of Judge Cannon, rapidly becoming not about the criminal defendant named Donald Trump and what he did, and is becoming an indictment of the special counsel and their conduct. Same special counsel that's in other courts, same Department of Justice that's been litigating cases for hundreds of years, but to Judge Cannon, the upside down world that she's created, they're constantly on their back foot, and every request that's made by Donald Trump is complied with by this judge, and she finds in an artful way, and it's not by accident, it's by purposeful calculation, to just make enough rulings that aren't rulings, paper orders that aren't orders, dates and deadlines that don't get canceled, they get extended, to stop Jack Smith from going to the 11th Circuit and asking for her removal and to have her reversed. And that is in sharp contrast to what's going on against the son of a Democratic president, about gun charges and whether he filled out a form or not appropriately when he was using drugs for a gun that he held for 11 days. So, Karen, why don't you, from a prosecutor standpoint and from all of that, why don't you talk about what you're observing with Cannon and where you think that case ends up before November? And then you want to touch on what's happening with Delaware federal court with the president's first son, Hunter Biden.
Yeah, look, I find this hard to analyze because this doesn't look like anything remotely resembling a normal prosecution or anything in the criminal justice system. This is the most head-scratching, perplexing series of non-decisions that I've ever seen anywhere. I mean, this latest series of rulings or whatever they're called, paperless orders, are just unbelievable to me. So just going back to this gag order request, just to contrast what's going on. This was an emergency request that the special counsel made. This was previously, but I want to contrast that with what's happening now. About a week ago, saying Donald Trump has put federal agents' lives on the line, put a target on their back, because he is going out saying that when the search warrant was executed at Mar-a-Lago, that they were authorized to assassinate him. And that couldn't be farther from the truth. There have now been congressional hearings where they talk about it and people have to talk about it. This is just an absurd assertion, and it's a lie. And what does she do when they make this request? Rather than putting a gag order or putting it on the calendar right away, okay, I see how urgent this is. This is lives on the line. I'm going to reject it because there was no what's called meet and confer, which is the parties are required in her jurisdiction and her local rules to do what's known as meet and confer and try and work it out first. And then if they can't work it out, then they indicate that in their papers. Well, based on everything people were saying about it, I just assumed there was no meet and confer. Well, actually, Jack Smith tried to meet and confer, and what did they say? Sorry, it's Memorial Day weekend, we're busy, we can't do it. And if I'm Jack Smith, I'm like, okay, but this is an emergency. I'm sorry that you won't meet and confer. And they put that in their motion, that this was their lame excuse. But this is urgent. So judge, I need you to do this anyway. And what does she do? Oh, we're going to brief it. We're going to have a hearing. We're going to talk about this. Never. Right. What else has she not ruled on yet? SEPA. There's still so many of these classified information protection Act documents that, again, national security information. They have to have hearings about whether or not what documents can come in, what can't, whether you can sanitize them, et cetera, to protect our secrets in this prosecution. She hasn't ruled on any of those either. Somehow that's not urgent. But you want to know what she's put on this calendar? You want to know what she thinks is important to stop the proceedings and stop this trial from happening? What did she calendar? This hearing to oral arguments to be able to discuss whether or not Jack Smith and Special Counsel and the Special Counsel's office was appropriately created and appointed, et cetera. Well, guess what? The Special Counsel is something that's been around for and upheld by countless district courts across the country, countless circuit courts across the country, and even, guess what, the United States Supreme Court. But no, Judge Cannon, who has been reversed twice in this case by the 11th Circuit, who's been on the bench for a hot minute, and who clearly is trying to do Trump's bidding at this point. I was trying to say it for a long time and say, oh, she's inexperienced. Oh, she doesn't know. She's new. There's no excuse anymore. No excuse that she would now, we have to have a hearing to determine this because baby Judge Cannon, who just got here and doesn't know anything, has been reversed twice. I'm going to discover something different than everybody else, number one. And number two, I'm going to allow something that I didn't even know was a thing. It's so rare, which is that these friends of the court, the amicus, who people submit amicus briefs all the time. What they do is they ask permission from the court to be able to submit amicus briefs. And usually the court says yes. And she's allowing that. She's also allowing them to give oral arguments. They're not parties to the case. So there's going to be strangers who have nothing to do with this, who are going to get to come to court and do oral arguments in addition to the parties. And that's what they're going to waste valuable court time doing, not doing any of the pretrial motions that need to happen to get this trial to go forward. So, and the one thing she's doing is she's not ruling anything, because if she rules something, it goes up on appeal, especially in SEPA, right? If she makes the wrong ruling in SEPA, that's definitely appealable by the Special Counsel's office. The prosecution can do that. It automatically gives them a right to appeal. The statute even says it. And so guess what? Next time, rather than reversing her, I think they actually yank her off the case, because this is ridiculous. I can't analyze this from a legal standpoint, because this doesn't have any resemblance to what actually happens in the law, in my experience. This is just a head scratching, talk about a judge that's conflicted and is absolutely partisan and not objective. That is Eileen Cannon. It is not Juan Merchan or Tanya Chutkin or any of the other, Arthur Engoron or Lewis Kaplan, not any of the other judges who have tried Donald Trump in the last year. Those are judges who are just normal judges, right? Eileen Cannon is as some people say, a complete loose cannon.
Yeah, and that trial is not going to happen before November. So, which is probably the simplest of the trial. I mean, the one that had the case that has the least moving parts, unlike even New York, is the Mar-a-Lago case. It's all Donald Trump. It's all Donald Trump with his fingerprints on the retention of the presidential records, not presidential records, the failure to return national defense information, top secret and classified, being caught, pardon me, red-handed with it, his conversations. Well, let me touch on that for a minute. Conversations with his lawyers that have been turned over because the attorney-client privilege has been stripped away from him. That's another issue that has not yet been decided. Pardon me, guys. Swallowed a bug there. Is the motion to suppress the evidence that they brought, arguing that somehow the search warrant was invalid, the way it was executed was invalid, and everything they found there should be suppressed. And, pardon me, trying to revisit the decision by Judge Beryl Howell, the Chief Justice of the D.C. Circuit Court, which she's like on the Mount Rushmore of D.C. and other judges, being called into question by Judge Cannon, who's been on the bench for like a hot minute. When Judge Beryl Howell, after an evidentiary hearing, decided that it was more likely than not that Donald Trump and his original lawyer related to Mar-a-Lago, Evan Corcoran, had committed a crime or a fraud, and therefore the attorney-client privilege would be stripped away from Donald Trump, and 50 pages of single-space notes by Evan Corcoran, his musings that he put into a recording, would all be turned over to the prosecution. Well, that issue's coming back up with now Judge Cannon. Oh, heaven help us about what she's going to do. And whatever she does, and I agree with you, the end game here that this is leading towards is a series of decisions that are appealable by Jack Smith, and that the 11th Circuit is likely chomping at the bit to get their hands on to reverse and or reassign her off the case. But by that time, by my watch, it's going to be well after November. And what we're still waiting on, even on this late recording, this late date of this recording of this live legal AF, is the decision by the United States Supreme Court, who took oral argument on the immunity decision, which has been holding up the prosecution of Donald Trump in the DC election interference case before Judge Chutkan for for the last 9 months. And of course, they took the oral argument the last day of the last oral argument in April, before they shut the doors to oral arguments at the Supreme Court. And we have been waiting since the end of April for them to decide. Now, let me answer the questions in the chat. Yes, the Supreme Court has to make a decision now that they've taken the appeal, the briefing's done, and they've issued an oral argument. Yes, it has to be this term. And the end of the term, technically for issuing the opinions, is when they all decide they're all leaving on their summer vacations. It's usually around now. It'll be sometime between now and next week, next Monday, Tuesday, Wednesday. By mid-June, this gate is closed, term is over, opinions issued. We're waiting on opinions, as I teased a little bit on Saturday, on abortion again, on gun control again, on immunity for Donald Trump, again, things related to Donald Trump, on Jan 6 convictions and counts that can be used against Donald Trump and others again. And so while that's all going on, the DC election interference case, even if Judge Chutkan were to get the ruling and it allowed her with some sort of mandate to do something with her case, pick between personal conduct and executive conduct or whatever it is that the Supreme Court rules led by MAGA, if she can get her case restarted, plus the 90 days that she said she's going to give to Trump to restart the case that's been on ice for the last 9 months, she can't start her case till August, maybe even September. Could she get it done before the November election? Maybe. Donald Trump's got no other criminal cases that he's going to be tied up in, so that could happen. But it's getting increasingly less likely, which of course is the end game for the United States Supreme Court to help out Donald Trump this term. Then you got Cannon. Could she have gotten her case up and running off an indictment 2 years ago? Absolutely. That case, because of the less moving parts, that case should have been up and running and tried before the Manhattan DA case, before Georgia, before the DC election interference case was even brought. And yet, you and I and Ben have to talk about the first week in June, a case that is inevitably not going to happen, even on appeals that you outline and I outline, because those appeals are going to be well beyond the time period that we said, which is, again, does Donald Trump have a judge that's trying to bend over backwards to help him out? It's obvious. It's obvious that he does. You want to touch a bit on Hunter Biden and just the 8 months issue?
Yeah, I mean, look, the Hunter Biden case, it's what strikes me is so ironic is that you've got Hunter Biden, who is being prosecuted by his father's Department of Justice, right? There's no other way to look at this. This is Joe Biden could have pardoned him. He could have not appointed a special counsel. He could have not allowed this prosecution, right? I mean, Joe Biden has the ultimate authority to do that, but he doesn't. He steps aside and he believes in our institutions. He believes in our criminal justice system. He believes in that preserving our institutions and not allowing partisan politics to infect the justice system is more important than any one person. And so that just goes to show you what a decent person Joe Biden is, and the contrast of what will happen if Donald Trump gets elected. He is going to hand out these pardons like candy. He is going to absolutely pardon himself, and he will go after, as he said, all his political enemies. Just one other thing to just show the difference, the contrast, is that you were pointing out, Hunter Biden was just indicted, 6-8 months ago. This case was just brought. How is it already going to trial? Mm-hmm. 8 months ago. How is it already going to trial in such lightning speed? Again, because nobody is out there doing, nobody's out there on the take for Hunter Biden to try to slow it down or the opposite, to kind of get him. They're just letting the system play out. And this is how it works when people don't get involved and when partisan politics is not involved. And that's again, just the contrast between Eileen Cannon and that case, how it's going. And what she's doing there, just so people can see the contrast. It's just unbelievable to me. If you think that Donald Trump would have one of his kids, any of them, Don Jr., on trial and being prosecuted while he's president of the United States, not happening ever. Right? He would never.
Or the first lady, or the first lady. Where was Melania during the entire trial? But First Lady Dr. Jill Biden. Yep, showing up every day to support her stepson along with his sister and all of that. Just shows you the difference between the two parties. We're gonna talk about, in our final two segments today, we're going to talk about the Wisconsin Attorney General bringing his new suit against people in the Trump inner circle, lawyers and presidential aides. And of course, we're going to touch on what the Atlanta Intermediary Appellate Court has just done to basically scuttle the prosecution of Donald Trump. I don't know about the others. There's 13 others, but certainly about Donald Trump before the November election. We're going to take a break for our sponsors. But first, let me just talk quickly about a couple of ways to support this pro-democracy network and this particular show and the contributors to this particular show. You've got watching us, always good, not ego, algorithm. That's what I like to say. You've got listening to us on all the major podcast platforms, free subscribing to the Midas Touch Network, helping it grow to 3 million free subscribers before the November election. We're building this network without any outside investors, completely independently, with our bare hands, with your help. So that's good. We've got Ben and I are doing a Patreon.com/legalaf. If you want to get to the nitty gritty of the law side of the intersection of law and politics, where we can drill down more on what we can just touch on, even on a full length podcast, then Patreon.com/legalaf is for you, with exclusive content you won't find anywhere else. And you won't even find here on Legal AF or on the Midas Touch Network. It's only exclusively there. There's membership levels. The entry level membership level is about the price of a cup of coffee, 2 cups of coffee a month, but you get a lot of value for that. It's for lawyers and non-lawyers alike equally. We have plenty of both. We try to make it informative and entertaining at the same time, like we do this particular show. And so that's Patreon.com/legalaf. And then we've got contributors that, we have, I don't call them spun off, but we have other podcasts devoted to law and politics, including one that's now anchored by Karen Friedman Agnifilo, and that is Mistrial. And she is anchoring that along with 2 others. You see Danya Perry and Kathleen Rice, and they bring it from a very unique perspective and an important voice. And that's going to be appearing regularly on the Midas Touch Network. Karen, congratulations on Mistrial.
Thank you. It's super fun.
Yeah. It's not super fun. Sorry about that. I didn't mean to step on you. It's not super fun. Atlanta. And we now have a ruling by the 3-judge panel, as I anticipated. I did a hot take. Oh, wait, I'm getting, you know what? This is why I love Salty. Salty's like, Popok, you forgot to do the ad break. So now, a word from our very important pro-democracy sponsors.
We've all had embarrassing BO moments. Fortunately, Lumi whole body deodorant is making it so none of us ever have to worry about body odor again. Unlike certain other deodorants, Lumi is powered by mandelic acid to control odor in a new way. It delivers outrageous 72-hour odor control everywhere from your underarms to your feet, and yes, even your private areas. In fact, it was patients concerned about their private area odor that originally inspired an OBGYN who invented Lumi. Fast forward 6 years, and her game-changing whole body deodorant has now earned over 300,000 5-star reviews from people like me who love feeling confident from head to toe. So there's a special offer here for new customers. Get 15% off all Lumi products with our exclusive code and link. Use code LEGALAF at lumideodorant.com. That's LUMEDEODORANT.com, and use code LEGALAF. I like Lumi because I like feeling fresh all over, and I like feeling fresh all day. I was a little bit skeptical at first about it, frankly, but I have to say I am totally sold. I like this whole body deodorant. I like that it was created by a doctor. That was my biggest misapprehension, frankly. But once I learned that it was created by a doctor and it was all about BO being misdiagnosed and mistreated, it made me really want to try this. And I love it. It's baking soda free and paraben free and pH balance for safe use everywhere. So they have great variety of fresh scents like clean tangerine, lavender, sage, or toasted coconut. So again, go to lumedeodorant.com and enter code LEGALAF at checkout.
Have you heard that the flavored air category is quickly becoming the leading alternative to vaping and smoking? It's a whole new movement towards better habits, led by the sponsor of today's video, Fume. Fume is an award-winning flavored air device, and flavored air isn't like vaping. If vapor was compared to sticky soda, Fume cores are closer to herbal teas. Fume has lots of delicious flavors to choose from, like crisp mint and orange vanilla. With flavored air, you can satisfy your oral fixation through a passive diffusion system that utilizes no electronics, vapor, or combustion. Instead, Fume draws flavor to your mouth. Fume fills the void ditching a bad habit can leave. There's no vapor, and you can use it anywhere. There's no nicotine, and it's not addictive. The non-toxic flavors are a guilt-free alternative. Fume doesn't use any batteries, so you'll never need to charge it. The design is super sleek, it looks awesome, and you can truly feel the weighted, high-quality design. I mean, one of the fun things about Fume is that it's made to fidget with and calms anxiety with magnets, snaps, and clicks. Fume continuously invests in third-party studies to ensure the safety of their products. My favorite Fume flavor is the orange vanilla. It's just as delicious as it sounds. And look, if you're trying to kick your bad habit, I couldn't recommend Fume enough. Fume has served over 300,000 customers, and you can be the next success story. For a limited time, use my code LEGALAF to get a free gift with your Journey Pack. Head to tryfume.com. That's TRYFUM.com and use code LEGALAF or scan the QR code on the screen to get a free gift with your order today. And we're back. And my free gift is always doing the show with you on Wednesdays and whenever else I can do it. So enough of that. Let's move on to Atlanta. It's easy. Just as we suspected, I did a hot take on this one. The Georgia Court of Appeals, the second highest appellate court in Georgia, has, without even having to be asked by Donald Trump, has decided the issue of whether Judge McAfee back in March properly ruled that Fani Willis should not be disqualified, although he had some pointed language in there against Fani Willis about her testimony and that of Nathan Wade. The odor of mendacity will go down in the annals of history about what he thought was some lying going on in the courtroom that he couldn't get to the bottom of, but kept her on the case. after 4 days of excruciating detail that I would like to forget about Nathan Wade, about Fonnie Willis, about their relationship, about his sex life, about her sex life, and all things that have nothing to do with what we're here for the criminal justice is to decide whether Donald Trump is guilty or not of crimes along with 13 other people. But the judge realized that, especially having basically planted the seed for appeal within the order that he entered, and certifying that appeal, that the court would get around to making a decision. Fonnie Willis, to her credit, I always faulted her a little bit, like she didn't push the issue about getting the case set for trial since March. We're already in June. She never moved. She never had a hearing. She never had a discussion about it. And there was no stay in place until now, but there is one now. And now the three-judge panel, randomly selected, 3 judges not from Atlanta, and they're from a very conservative right-wing part of the state. And you can do your own math related to that. 3 men, 3 white men, have decided that they're going to stay the case, and they don't want any further proceedings going on, certainly not the setting of trial. So there's a pin in the case until they get around to deciding the issue. Now, they've set a October. They must be so busy there about things that matter to our democracy. They just can't get around deciding this case and having oral argument even until October. It doesn't mean actually that they're going to have oral argument in October. It's a control date on their calendar. They will decide as we get closer to October and after full briefing so there'll be 3 total briefs and a record brought up to them on appeal. They'll let the parties know in advance of October whether they're even going to have oral argument in October. But if they are, and it's likely they're going to, then sometime after that October date and at the end of the term, which happens to be March of 2025, they will enter their ruling. And in the meantime, the entire case is stayed. It's such a sad state of affairs. And we had so much hope and put so much of our eggs in Fonnie Willis's basket early on. I mean, she did everything right. And I'm not claiming she didn't do everything right, but she did everything right. Yes, Alvin Bragg broke the glass ceiling there. First to indict, first to prosecute, first to convict. I love that, especially given Alvin Bragg's having taken some unnecessary criticism and pot shots at the very start of his being elected to that office. But Fonnie Willis, we were, oh my God, she's got him. She's got the goods. She's got the taped phone call. She's got the witnesses. She's got the fake electors cooperating. She's got, she flipped 4 and 3 of them being lawyers from Donald Trump and got theirs, whatever type of cooperation she got. This is a great case. And then this effing circus and soap opera, salacious going through the boudoir of Fonnie Willis. And some people I know are criticizing her. She brought this on herself. Why did she have to date Nathan Wade? And we've gone ad nauseum here in our positions about whatever she did at her off time is not relevant to her decision to prosecute. The indictment that was brought by a grand jury in Georgia, not Fonnie Willis, on the recommendations of a special purpose grand jury, not Fonnie Willis, based on evidence that was presented to them, and then who gets paid when and who has a drink with who after has nothing to do with the administration of justice. And that's where that is. But of course, to these 3 right-wing white guys, this is interesting. And why don't we do what Judge Cannon does and others do and the Supreme Court does, which is kick this can so far down the road that you don't even know what road you're on. And then we'll pick up with it when it really doesn't matter any longer after the election. And if Donald Trump were to win, this case will be inevitably delayed until he's out of office and 88 years old. If he loses, then we'll have to see what happens, whether Fonnie Willis is still around after these inevitable appeals. I know you have very strong opinions about the original motion to disqualify and how Judge McAfee handled it and then invited this appeal. And so where are you at with all this, Karen?
I mean, yeah, exactly. We're in this. This was much ado about nothing from the beginning. And this is just a racist, misogynistic double standard that they're applying to Fonnie Willis and Nathan Wade, who are two consenting adults who are people who are, he was a judge, she's an elected prosecutor. And I mean, it was not like there was no conflict at all. And they just went after her. And Judge McAfee, who I actually really like and think he is a really good judge, I think was just didn't know what to do with it. And he just let it go. He could have, he had the circus of a hearing where there was almost nothing about what the conflict would be and all about the salacious sex details just to embarrass them. It just had nothing to do with whether or not there was an actual conflict of interest here. Again, they were on the same side of the aisle. There was no prosecutor sleeping with the judge or sleeping with the defense attorney kind of thing. And so therefore there was, some kind of conflict. This is colleagues. And I met my husband in the DA's office. He was 2 years senior to me, but whatever. Now we're married. Like, it happens. And this was a consensual relationship. This was not like a boss and her underling, right? This was whatever. Anyway, it just frustrates me because the hearing, which I went down a rabbit hole and lost several days of my professional life because I didn't stop watching it because it's televised, partly because I just couldn't believe it was happening the way it was. I just can't believe how much Judge McAfee lost control of that hearing. And like I said, if he needed to have a hearing, I don't think he could have or should have. I don't think there was a conflict at all. But okay, you want to have a hearing to establish that? Focus it on what could cause a conflict, right? What went into the hiring decisions of Nathan Wade? Is he qualified? And again, how about who decided when to pay him? How did you audit his hours? All the kind of things that could maybe perhaps look like a conflict. Or at least somehow develop that record was never developed. They never even talked anything that was remotely about a financial conflict. And I can't imagine what other type of conflict there would be there. But he let that crazy record get made. And then he said, oh, well, there's an appearance of impropriety. I'm not really sure what that is, what the appearance is. Spell it out. He never spelled it out. What is the impropriety? What is the appearance of it? I just don't get it. And it's just, they don't like that there are people having sex and, it's a woman and they're Black, God forbid, these white guys, like I swear to God, this just stinks and reeks of racism and misogyny to high heaven. It really does to me. And here we are. So it's the South, it's the deep South. And now this case isn't going ever. I mean, I'd be shocked if this case ever goes to trial. Either Donald Trump wins the election and it doesn't go. Also, the presidential immunity decision that we're waiting on from the Supreme Court, that's going to impact the conduct here, of course, too, because whatever standard applies there is going to have to apply here, too. So that's going to impact it. And I'm sure either way, whether he wins or loses, the Georgia governor is potentially going to pardon him. I mean, I know it's not completely up to the governor in Georgia. I know that.
Well, it's not up to the governor at all. It's up to a panel.
Right. But those types of panels are political, and there are people like governors have influence, and you never know. You just never know. They'll either feel sorry for him because he lost the election, he's been punished, or he's been hurt enough, or he won, and so we can't do it. One other open question is going to be what happens to the rest of the 14 defendants who will be left. Some have pled guilty, only a few. And what will happen to those cases, right? What will happen to the guys who have already pled guilty, and what will happen to the other open cases? This impacts all of them, not just Trump. So this case is dead. Don't ever expect this case to go, at least against Donald Trump, in my opinion.
Yeah. I want to just take a look at something about the Board of Pardons and Paroles in Georgia. One of the reasons that, just so people know, that most governors are able to do what Karen outlined, which is to pardon. Like, there's been pressure on Governor Hochul here in New York to, including by some Democrats, which was bizarre, to pardon Trump for the good of the country. Not happening. But in other states that have had frequent corruption at the governor level, they've taken away the right of the governor to do that, because Georgia had some corruption issues where people were paid bribes and governors were paid bribes. And for people who think that stuff doesn't happen, I just caught it's not directly at the intersection of law and politics, but there is a federal case that's going on right now that while the jury was deliberating, a federal case about the misuse of COVID funds to the tune of 30, 40, $50 million. One of the jurors got delivered in a gift bag to her home $150,000 in cash with a note that said, there's more where that comes from if you vote to acquit. This is not a John Grisham novel, although it sounds like it. Just happened in federal court. Somebody thought it was appropriate. And, you got to think, I'm thinking when Trump heard that, like, is that a thing? Could I have done that? And no, it's not a thing. And that now they're talking about dismissing the jury and starting all over again and looking into the crimes that were committed and trying to influence and tamper with the jury by flashing cash. But there's been that historically, organized crime trying to. We've had the murder of jurors in this country. So when we talk about doing your civic duty, it's not without risk, which is why we're so hot and bothered on this Legal AF and on Midas Touch about the protection of the criminal justice system and jurors and all of that, and prosecutors like Phony Willis from being pilloried and excoriated and crucified by what ends up being right-wing MAGA, and therefore delaying what everybody of every stripe and every political leaning should want, which is a public justice system that tries our people, regardless of what their political position was or what their presidential position was, but tries them in public so that we know whether they are guilty or innocent, and we know that information before we have to pull the lever for them on voting. But that doesn't seem to matter anymore in Georgia, so we're going to have to continue to follow all things related to that. And linking Georgia to Wisconsin is relatively easy. It's through the person of Mike Roman. It is Mike Roman and Mike Roman's lawyers who brought and put together the original motion to disqualify Phony Willis that Donald Trump jumped on and ended up using. It was Trump's lawyers that did the better argument, but the papers were originally put together and filed by the stalking horse of Mike Roman, who was the election day coordinator for Donald Trump. And he was the one, along with Ken Chesborough and Jim Trupis and Giuliani and Powell and Eastman and others, who developed the fake elector scheme. And then Mike Roman was the mule who got the fake elector certificates from the various battleground states, first having them meet, having them fill out these phony certificates and put all sorts of wax seals and ribbons on them to make them look official, and then have them then collect them. And in fact, the reporting is based on emails and other things and videos and audios that have come out that Roman was getting frustrated because they couldn't get these things fast enough. They had to get them into the hands of Mike Pence because Mike Pence needed to recognize these things in order to say that I can't figure it out. It's so hard. Fake elector certificates, real elector certificates, turn it over to the state delegations, which are dominated by Republicans, and make Donald Trump president. That was the plot. And so Roman got indicted in Georgia and led what I just said in Georgia to disqualify Phony Willis. And you see what happened there. But he's not out of the woods yet. The Wisconsin Attorney General and his office has obtained an indictment that just came out the early part of this week, signed by it comes out of the DA, it comes out of the Attorney General's office. And this is a conspiracy case. It's actually a criminal complaint. I say it's an indictment, but it's really a criminal complaint, not coming out of the grand jury, coming out of this office here. And in particular, they've now indicted Trupis, Chesborough, and Mike Roman. Each one of them had their own individual role and then collective conspiracy role. Trupis and Chesborough are the two guys that ended up in the White House, a meeting having been arranged by Rance Priebus, who used to be the White House chief of staff and came out of Wisconsin also, and got him a meeting with Donald Trump. And that's where the actual Jan 6th fake electors thing got hatched, where Ken Chesborough met privately with the president, with Jim Trupis there. He was only supposed to be there for a photo op. And he decided to tell Trump, hey, Jan 6 is your drop dead deadline. And if we get these elector certificates and these lawsuits, this might work. And really? And then that was what lit the fuse. Troopus is there. Troopus is exchanging emails that have all been made public. The reason they got made public is very unique. Troopus and Chesborough, along with others in the fake electors, got sued civilly in Wisconsin as part of the settlement of that case brought by normal citizens, average citizens brought the case. They had to agree never to interfere with elections in the future, never be fake electors again, never challenge electors again, and they turned over all of their emails and texts, including with Mike Roman, that Troopus and Chesborough had. But that was civil. That wasn't criminal. And then we now have this criminal complaint. And my favorite part of it is the exchange between Ken Chesborough and Mike Roman, who's the election day coordinator. Chesborough wrote a couple of memos. Well, yeah, throw it up now. Chesborough writes a couple of, he wrote like 4 fundamental memos about outlining how to use fake electors, alternate slate of electors, combined with lawsuits to throw a monkey wrench into the Jan 6 certification and the peaceful transfer of power. But as that continued, and as it was almost like a telephone game, by the time that plan got reiterated to a number of other Trumpers, they stripped away the requirement of any viable lawsuit. And they used to have, like, their certificates that actually have a legend that says, some certificates, only use if lawsuit successful to challenge, voting and voting fraud in a certain state. But other states, that was stripped away. Chesborough is caught in a text exchange with Roman that's now a part of the complaint, where Chesborough says, it's on page 12, Mike, this is Chesborough to Mike Roman, I think the language at the start of the certificate, this legend, should be changed in all of the states. Let's look at the language carefully. He wanted a legend that said only break glass in case of emergency, and lawsuit is pending at the time of the use of the fake certificate. To which Mike Roman says, I don't think there needs to be a change. And then Chesborough says, I can help with drafting in a couple of hours. To which Roman says, about the fake electors and everybody participating in the conspiracy, fuck these guys. Because all he wants is the fake elector certificates. He doesn't want any legends on them to get them into the hands of Mike Pence. And this complaint also cites to lots of emails and exchanges that came out of the civil case against Troopus, that Troopus and Chesborough basically were their own worst enemy. They didn't take the Fifth Amendment. They turned it all over along with others. And this is the result. Now, there's a couple of pending questions. Why weren't the fake electors in Wisconsin also indicted? Will they be indicted? Is there a grand jury? And what happens next with these 3 guys who need to be arraigned sometime in early fall? What do you make of this new indictment by Wisconsin following the lead of Chris Mays in Arizona?
Look, I mean, it's about time, but I had all the same questions you had. Why weren't the fake electors? Why wasn't Donald Trump charged? Any thought that Ken Chesborough was cooperating, that for 5 minutes we all thought he was. I think it's pretty clear he's not. Look, it also, it just brings up why these 3 and not anybody else. Sometimes it's because sometimes because of the statutes that different states have, they could easily prove it against these individuals, but maybe the fake electors in Wisconsin, they felt were kind of duped by these guys. So maybe that's why they weren't, who knows what the actual reason is. Prosecutors aren't supposed to bring a case unless they can prove it beyond a reasonable doubt. And so maybe they just thought these were the 3 strongest ones, but there's a lot of head scratching nationwide about why these people and not the others. I mean, why is Jack Smith not indicted the unindicted co-conspirators in Jan 6? It makes no sense. Why all the other unindicted co-conspirators? They could have done it as a separate indictment. So it's unclear to me why it was done this way. And as you pointed out, this is a felony complaint, not an indictment, which means it's a summary. You file that with the court, and you get arraigned on that, but you still have to indict it in a grand jury. So who knows? Maybe they're in the grand jury, but why did they do it this way? Sometimes you can skip this and go to the grand jury. So we just don't know enough yet. But it's clear to me that Ken Chesborough is either not cooperating the way we kind of thought he might be, or he tried to cooperate and he's such a liar that they just said, screw that, we're doing this anyway. So,
Yeah, that's a very good observation for our audience too, about the difference between a criminal complaint, not as a substitute, but precursor to an eventual indictment by grand jury, and where they might be in that grand jury process, including with the fake electors. Kudos to the attorney generals. A lot of them stayed on the sideline waiting for the federal government, the Department of Justice, the special counsel do their job. They got big-footed in a way by the special prosecutor, special counsel, and they waited on the side. But they have their own independent criminal law enforcement duties. Many of them are the chief law enforcement officer of their state, not quite in New York, the way that's outlined. Tish James has some, but very limited criminal powers. It's really in the hands of the district attorneys, including the Manhattan DA that we talk a lot about. But in other states, it is the chief law enforcement officer, and they go after with full criminal powers and investigatory powers. And that's what we're seeing there in Wisconsin. But now they're kind of getting off the mat, and they're saying we got our own election integrity to protect. Our voters were misled, undermined, disenfranchised, and we have to do something about it. I mean, especially now. I mean, Fani Willis had the most sprawling indictment. She bit off a lot when she filed her indictment, whereas Jack Smith was much more surgical, 4 counts, 1 guy, a whole bunch of unindicted co-conspirators, but that was it. She did, let's talk Wisconsin. Let's talk about, now that case is completely sidelined and disabled on, the side of the road. And now that is one of the reasons I think the attorney generals are stepping forward, some more aggressively than others, but this fake certificate, fake elector plan was implemented by MAGA and Trump in 7 battleground states. And so far, you and I have reported on 2 of them. And this is where we're at. So we got to continue to follow it. It's another way for justice, just like Chris Mays did not indict Donald Trump for now. They did not indict yet Donald Trump here. They're all I think everybody's sort of waiting for the Supreme Court decision about how to shape the contours of any future indictment of Donald Trump if they're thinking about doing it. And I think that's probably proper and professional to do it that way, because you're just going to get caught with your pants down if the Supreme Court tells you to do it one way and you didn't do it that way. So I kind of get the guidance that they're waiting on. We fault the Supreme Court for making this guidance come so late on purpose. But that's where we're at. So Karen, we got a lot to talk about. We got a Supreme Court who's going to, by the time you and I probably meet next week, we may be talking about Supreme Court rulings about abortion, whether EMTALA, the Emergency Medical Procedures Act and all of that, federal Trump's abortion bans in various states when the life of the mother is at risk. That's now been decided. The Supreme Court can't help itself but to continue to tinker with reproductive rights and the autonomy of women. They just can't. They got to keep taking abortion cases and making rulings about it. And they're always bad.
I saw a funny. I mean, it shouldn't be funny, but a funny thing on Twitter. It's how Justice Alito can't control his own wife, but wants to control yours. Yeah, that
is a dysfunctional, abusive marriage, and I don't care.
I don't either. Do you think, by the way, speaking of the Supreme Court, do you think they're going to, sometimes they take similar cases or they drop decisions of similar cases on the same day. Do you think they're going to drop the presidential immunity case and the 1512, which charges can, you think both of them are going to
Congress?
Yeah. You think it's going to be on the same day?
We're talking in shorthand. So abortion's up there. Guns, we're waiting on an opinion about guns. And listen to this one, Karen, to remind you and our audience. This one is whether perpetrators of domestic violence can have their Second Amendment rights to carry a gun forfeited. I think the answer to that should be yes. You abuse your spouse or others, you shouldn't be able to carry a gun. But it's up for grabs with this United States Supreme Court. We're waiting for the decision in the next week or two. That's guns, that's abortion, and then immunity you just talked about. And then the fourth one, there's about 5 major ones. The fourth one, which I agree with you, I think it's linked and they drop them together, so to speak, is the obstruction of official proceeding, which was the highest charge other than seditious conspiracy that was used by the Department of Justice for 300 Jan 6 defendants, including Donald Trump, although I think Donald Trump's probably survived, but who knows. And the argument there, because a trial judge, Judge Nichols, ruled that, no, that's not what that statute's for from 2000. That's financial crime. That's white collar crime. That comes out of the Enron era. That you can't use that unless they got their hands on the actual certificates during Jan 6 and rip them up. That you can't. That's not the obstruction of official proceeding that Congress had anticipated, and that's the argument. If that gets stripped away, 300 people, if that was their only charge, get their entire case exonerated. They get exonerated. They get their conviction vacated, and that's it. They don't get their time back. We got a guy that just got out, Brandon Fellows, who went to jail for that, came out after 3 years and that in contempt. So that would happen. Others that had other counts, then they'd have to be resentenced on the other counts, but not on that count. And then the question is whether Donald Trump, if that DC election interference case ever gets back up and running, whether 2 of his 4 counts, which are for election interference, although his level of election official proceeding interference is greater than any of the Jan 6 who were violently attacking the Capitol, but Donald Trump had a plan, and that's a little bit different. But yes, I think that gets dropped on the same day, and then the others sort of get dropped. And then as soon as the one that they're worried about most, which is immunity, about the shit they're going to take for what this ultimate ruling is going to be. I'm cursing a lot on this show. I apologize. That's going to be the last day, because that's the day that they are already in. When that gets released by the clerk, they are already in the air, flying to their respective junkets paid for by, in the case of the Republicans, right-wing MAGA, off to Europe, off to whoever, Iceland for the summer. And, you know, in the air when the opinion drops, because they're all, let's be honest, they're all cowards, at least on the right side of that aisle. So, yeah, I think you and I are going to be talking, and Ben, we're going to be talking about a lot as each one of these things drop either together or separately over the next week or two.
Yep, a lot going on.
Karen, yeah, thanks for being with us. I know you're on the road for good reason, and look forward to Mistrial, watching it regularly, and, of course, support us by doing Legal AF, patreon.com. So until our next Legal AF midweek with Karen Friedman Agnifilo, and then we'll catch everything up on Saturday with the weekend edition, which is Ben Meiselas and me. And then we do hot takes all along the way right here on the Midas Touch Network and on Legal AF. We've reached the end of our show today, so we're going to have to do a shout out to the Midas Mighty and the Legal AFers.